Geordie, thanks so much for joining us from People and Culture Strategies. So we're going to talk about redundancies. Maybe this is going to feature more prominently as we head towards the end of the year, because of course forecasts that the unemployment rate is going to rise as the economy comes under further pressure.
Yeah, absolutely. We've already started to see a number of high-profile layoffs and downsizing occur, and I think the sense that we're certainly getting amongst the client base that we're dealing with is that there's going to be a lot more movement in that particular space. So watch out for a significant number of redundancies, and probably a lot of challenging around when a redundancy has or hasn't happened.
Okay, so when we talk about redundancies, is that the same thing as a retrenchment?
Yeah, these two terms are often used interchangeably. The theory and best practice when we're talking about these kinds of matters is that it's never a person that is made redundant. It is a role or a position that is made redundant, and as a result of that redundancy of position or role, it may be that a person is retrenched. Now, I say may be because in certain circumstances, a role or position can meet the test of redundancy, but a person can be redeployed into an alternative role within that organisation, or potentially in some instances into another organisation. And so it's always the role that's made redundant, and it's the person that may be retrenched if they can't be redeployed. And interestingly, this definition of what is a redundancy is really an important one, and one that we've started to see over the last couple of years cause a lot of consternation for both employers and employees. The legal definition of a redundancy is when the employer no longer wishes a position to be performed by anyone. And I think there are some critical aspects of that. The first is it's once again about the position. So if an employer, for example, ceases to like an employee, or an employee falls out of favour with that employer, that doesn't mean that their role is redundant if the employer parts ways with them. That's, if anything, a performance issue, or seeking to invoke the notice clause of a contract. So it's when the employer says, look, it doesn't really matter who would be doing this role. I don't need that role to be done by anyone. And so what we see play out increasingly is, well, what happens when you need parts of a role to be done? Does that meet the legal definition of redundancy?
But of course, Joy Depp, as we well know, anyone who's the target of a redundancy, they're going to take it personally, aren't they? Perhaps that it's a reflection on their own abilities and that they're surplus to requirements. So how should the employee approach that redundancy then?
It's a very interesting issue, Andrew. I mean, what we see happen in a lot of organisations, as strange as this might sound to some, is redundancy is for many people aspirational. It's not unusual for someone who may have been with an organisation for 15, 20 years, and they know that their employer may have a generous redundancy policy whereby they might get 4 weeks per year of service, which gets them something like 60, 80 weeks of pay, so well over a year's pay. It's going to be taxed really generously with that period of service. So for a lot of people, they actually aspire to be getting a redundancy, because precisely in that situation, they're going to get a significant amount of money, taxed well. They are probably going to be in a position where they can find another job, and it means that they haven't been exited for reasons to do with anything that they've done wrong. But for other people, as you quite rightly say, what they've observed happen in their organisations is that redundancy is just a backdoor way, or a polite way of parting ways with someone who the employer may not have liked, or who has fallen out of favour. So it's very much this two-edged sword, and a lot depends on what policy, if any, an employer has over and above the legislation, which is not anywhere near as generous as what a lot of employers would have.
All right, so Jude, with the prospect perhaps we're going to see more and more redundancies as time goes on, what should employers be doing in this space then?
I think the most critical guidance I can provide to employers is to try to navigate this situation where there's likely to be role change for a lot of employers within their organisations. In other words, it's not going to be a 0 or 100 type situation where a role is no longer going to be required to be performed. Instead, it's going to be a situation where maybe 30, 40, 50% of that role may no longer be needed to be performed by anyone, but the balance of it still will. Now, what employers have to get better at is being very clear with employees as to, through their contracts and other things, that those kinds of changes are permitted, acceptable, and that's not going to trigger a situation where the employee can say, well, no, I'm going to claim that you've made my role redundant as a result of that change. This is going to be the biggest watch out for employers. And as with many things in the employment relationship, the more transparent you are, the more proactive you are, you're going to avoid the legal disputation that could otherwise arise.
Is there a difference here in the way this is handled, I guess, the size of a business and I guess the generosity of that business you talk about in terms of the payouts and so on? Is that more likely to be the case with those larger businesses, where in small and medium-sized enterprises, less so?
Yeah, I think that's right. And often what we see happen, particularly in the smaller businesses, is that the attention to detail in terms of the formulation of contracts and just getting those position descriptions right and allowing that flexibility that actually smaller and medium-sized businesses need a lot more, because they don't have the abundance of resources that larger employers are going to have. So I would encourage smaller and medium-sized businesses to pay closer attention to these matters, particularly through their contracts and particularly through their communications with staff. Absolutely.
All right, and what other avenues? I mean, if an employee feels as though they've been aggrieved here and that it's unjustified in how they're seeing the overall operation, perhaps they have been targeted, what are their avenues?
So under Australian unfair dismissal law, where a termination has taken place for reason of a genuine redundancy and subject to the consultation requirements being complied with and redeployment being explored, but if you can tick those boxes, then an employee is not going to be able to bring an unfair dismissal claim against their employer in a redundancy situation. However, what we see happen, and what an employee can still do, is argue that even though it's not an unfair dismissal claim, they may argue a quasi-discrimination claim. For example, if they feel that they were selected for redundancy, perhaps because of their age or perhaps because of having taken a period of parental leave. Any number of those kinds of background factors or attributes or circumstances can ground either a pure discrimination claim or a claim under the Fair Work Act for what's referred to as an adverse action claim. In other words, the employee argues that they were subjected to adverse treatment, in this case being selected for redundancy, as a result of those facts or circumstances which are protected by the law. So just because you can't bring an unfair dismissal claim as an employee doesn't mean that from an employer's perspective there can't be some kind of challenge.